Valid termination or not? Sabi ng babae pa, freedom of expression ko to. That is my freedom. I believed. Eh, ang angas-angas na eh. Anong sagot ng Supreme Court? Who says, yes, you can terminate? Who says, no, you cannot terminate? What did the Supreme Court say? Valid termination! Bakit? Anong diferensya doon sa kabila? Sabi nga nitong babae ito ng Supreme Court case, bakit nga yung Samson nagsalita? Doon Samson na to, in fact, she used this as a case. That Samson case, lasing na nga, nag-dirty finger pa. Sabi din Supreme Court dito, hindi siya lasing dito eh. Diba? She was not out of control of her mental faculties. She deliberately did it. She was not lasing. Sabi ganyan, the reliance on Samson is misplaced. Here, the other guy had drunk alcohol and his tongue was loosened by the alcohol intake. Here, it was an unwillingness which was voluntary and deliberate. And please take note, look at the way she said, she wrote the aspersions against the person. It was personal. It was a personal attack. Ano yung sa Samson? Sabihin mo kay EDT, bullshit yan. Hindi sinabing bullshit ka. Bullshit yan. Anong ginawa dito? Anong sabi niya? Bakit ba? Ang angas-angas mo. Di ba? Ano yung sabi niya dito? Paano bang palagi kang iniisahan sa trabaho? Ito so personal. The attack was personal here. That is the difference between that Samson case and this Lorna Halloween case. So, if it is a personal attack now, then that is a ground for termination. And hindi siya lasing. Okay? Now, this is the case of Colegio San Juan de Letran. This woman, Belen Villas, was a teacher in high school. She applied for study leave grant, 6 months. And then the principal granted her a 1-year leave without pay though, with the condition that the documents showing compliance with the study leave grant was supposed to be given at the start of the next year. So, at the end of that leave period, she was now requested to give her documentation. Ito lumabas sa documentation na first semester Old Testament course plus selling insurance and footwear. Second semester 12 units education subjects. Ang tanong, can you terminate? Kasi dito terminate siya. They went all the way up to the Supreme Court. Why? The school said there was failure to submit proof of study during the first semester in violation of the study grant, and she was engaging in work during the study grant leave. Now, what did the Supreme Court say here? Can you terminate her or not? The Supreme Court said this was illegal termination. Why? Because in the first place, the failure of that woman to find out her for education subjects was a mere error in judgment and not a deliberate effort on her part to disregard the rules and regulations of the school. Hindi lang niya na intindihan na, na-late na ako pag-file or may kulang pala ako mga documentation, kaya hindi siya naka-enroll. Now, on the other hand naman, with respect to yung nagbenta daw siya ng insurance, but this was study leave without pay. If it was study leave with pay, then you can question that. So this was an okay decision on the part of the Supreme Court. Now, questions on failure to disclose employment with other schools or companies. You have the case of Tatoro versus UST. Now, what happened there? As with most of us, we have a clause in our manual saying that you cannot teach in other schools without getting the prior approval of or prior permission of the school officials. Okay? Now, what happened here was that this faculty member was found to be engaged in full-time work with the ombudsman. And when UST found out, UST reverted him to part-time. Please take note, the UST did not terminate him, but he was reverted to part-time status. So hindi natanggal, ni-revert lang sa part-time. So he filed a case questioning the deloading. Is this a valid exercise of management prerogative? Sabi niya. Inakyat niya sa Supreme Court. Tama ba yan? Na ginawa akong part-time, tiniload ako? Sabi ng Supreme Court, yes. Why? There is a factual reason for it. They wanted to ensure the quality of education. So sabi niya, the faculty code explicitly states that they must submit each semester a statement of the number of teaching hours. The rationale is to maintain the UST quality of education. Okay? So there is factual basis for the loading. However, what if you were to terminate the employee on that account? This is the case of San Sebastian. Moreno versus San Sebastian. This is a 2008 case where the faculty member was actually caught and she admitted having secured prior permission. She failed to secure prior permission before teaching in another school, in violation of the faculty manual. And then what did the faculty manual in San Sebastian say? Sabi dyan, dismissal. Ang defense naman itong teacher na to, there is a need to augment income due to financial difficulties. Question, can you terminate? What did the Supreme Court say here? The Supreme Court took note of these following circumstances. She was a first-time offender. There was voluntary admission of guilt, despite the fact that faculty manual, the penalty is dismissal. So, considering all of the foregoing, the Supreme Court said, no, you cannot dismiss. The misconduct here falls below the required level of gravity as would warrant dismissal. The willful disobedience of an employer's lawful order must be characterized with a wrongful and perverse attitude. Here, the school failed to prove that the faculty harbored perverse or corrupt motivations in violating the aforesaid school policy. The Supreme Court ended here. Ang sabi ng Supreme Court, you cannot terminate under the circumstances kasi meron daw first-time offender, voluntary admission of guilt, at saka talaga nangangailangan ng pera. So you take it on a case-to-case basis. The question, however, is, sige, hindi natin siya i-terminate. What if she continues doing it? What if she continues doing it? She's already been informed that you cannot. So maybe you can now try the case and say, you can terminate because this is now willful disobedience. But please take note, there is no Supreme Court case yet on all fours. This is also a deprivation of the employee's right to gainful employment. So what is the interest of the school as against the interest of the teacher? The need to augment income as against the school's need to ensure quality of education. That is where the balance should lie. You have to think of the balance. There should be a way to determine this creatively at that. We have to ensure quality education. That's given. I do not see any problem with that. But in determining the case, also look at it on a case-to-case basis. Kung talaga mababa yung sweldo, paano ngayon yun? So you also have to be practical. But I urge you to look at creative solutions to strike the right balance. Let us temper justice with mercy.